Your responsibilities as guardian. Hi, I'm Darren Findling of the Probate Pro, and we're going to examine a particular form used by the Macomb County Probate Court when you're involved in a guardianship context. This particular form is used for adult guardianships, and it gives the basics, the ABCs of your responsibilities when serving in this particular role. As you can see from the name of the document, it is simply your responsibilities as guardian. And it's designed for guardians or prospective guardians. But again, it's not for deceased estates or for conservatorships, although the form discusses some issues relating to even when you're in a conservatorship context. Let's work our way through the document. The form is called MCPC 33, and as you may see from the bottom left corner of the form, you'll note that it says your responsibilities as guardian of minor. This form has a typographical error. This is actually designed for the adult guardianship files, not for the minor guardianship files, and the court just failed to update it with the correct title. This is for guardianships of adults. The top left corner would identify the county, and the top right corner the case number. As you can see where it says in the matter of, this is the name of the person that is under guardianship. So that's where that information would be contained. With all of these forms, as well as any processes involving probate, we strongly urge you to be working with a skilled, competent probate lawyer to navigate through the process to be assured that you don't make any mistakes along the way and that could get yourself into a whole heap of trouble. This section here gives some of the basic pieces of information that are really important that the court wants you to be aware of. So first, it says, tell the court if your ward dies. Now, again, they use the word ward, which is really unfortunate because a lot of people don't even know what that means. The ward is the individual upon which the guardianship is on behalf of. So rather than identifying them with those terms, they use the term ward. So if the ward dies, meaning the person under guardianship dies, you have to give a death certificate or obituary to the court because that will naturally trigger the termination of the guardianship itself to be able to allow the guardianship to come to a close because the guardianship terminates at death. It wants you to send it to the court. It gives you the court address. It also wants to know if the ward's address has changed and or your address as guardian has changed or phone number. Now, there are all sorts of reporting requirements and noticing requirements under the court rule and statutes. So this is really the opportunity for the court to always be updated to the correct identification of the address of the individual as well as contact information. And it specifically says you have to do so within 14 days or you risk being suspended. Now, we know that when you're moving, often you're worried about getting the utilities turned on, all the things that go on with moving from one location to another, but you also have to add to that list to make sure that you update the court. In fact, you should update the court when you're aware of anybody's address has changed, whether it's you, the ward, or an interested person, because so much of the court process is giving notice of events throughout the guardianship process. So you want to keep the court apprised of current addresses and telephone numbers. Now, this next section speaks to when the court appoints an attorney to do what's called a guardianship review, and that occurs on a yearly basis. Now, after year one, it will occur, and then it'll occur after 3 more years. But this causes a lot of confusion to people because they've been appointed guardian, they get a phone call or a letter written by a lawyer saying we're coming out and visiting. Well, that visit is appropriate under the statute and court rules. And again, we want to make sure that they show appropriate credentials, but assuming that they provide you with the court order appointing them, the law requires that in every adult guardianship case that it gets reviewed after year one and at least once every 3 years. And that is designed to make sure that there aren't any guardianships that are being mishandled or that the guardianship remains for years and years and years on end without appropriate housekeeping by closing out those guardianships. So again, somebody from the court will contact you, make sure that they show appropriate credentials, and be aware that they're going to do a report called an annual report for purposes their annual reporting to let the court know that there's a need for the guardianship to continue. This is different than your annual reporting, which is the next section here in bold. It speaks about the requirement at least annually to do an annual report. And even if that person comes out and does the visit to indicate that there's a need for that guardianship to continue, that annual reporting requirement does not go away. You got to do it each year, the annual report on condition of ward or legally incapacitated individual. That form can be obtained through my office. I've done videos explaining how to do that form, and that is filed with the court each year on the anniversary date of the letters of guardianship. And again, it's really critical that you do this, because if you don't do it, you will get suspended. You will get suspended in your role, and all of a sudden your powers that you will need for all sorts of purposes will get suspended, and you won't be able to act. So it's really important that you calendar these events on a yearly basis to make sure that you do it. Don't wait for the court to send it to you, because the court sometimes doesn't send it to you, or maybe it gets lost in the mail. It is your responsibility to complete the form and then file it with the court. And again, you'll see with that court form, the annual report form, there are all sorts of reportings about how the individual's doing, the medical visits, their location, etc. So we urge you to keep really accurate information, which we'll talk about in a moment, throughout the guardianship process, so that when you get to the annual review, the form is really simple to fill out because you already have the information readily obtainable. The next section talks about the record keeping piece, which is what we spoke about, and it broadens it to both guardianships as well as conservatorships. So remember, guardianship for care and well-being, conservator to conserve money for financial purposes. They may be the same people, they may be two different people. Some guardianships have a conservator, some conservators have a guardian, but some have both, some have neither. So you really have to understand what's going on here. But this particular section says after receiving your letters of authority, so in this case, your letter of guardianship or letter of conservatorship, change the address of the ward so that the mail that they'd be receiving comes to you. Remember, the U.S. Postal Service has an expiration date. If you don't keep that updated, the mail won't make its way to the appropriate recipient. So you want to start changing addresses as well as letting the post office know so you can receive the mail to keep up to date on bill paying, medical information, and so on. Now it talks about creating a file for each ward. So let's say you're the guardian of 3 people or maybe 1 person. They want you to keep a file. And that word file can mean all different things. It can mean paper, like a folder. It can mean like a Penaflex that some people use. It could be a digital type of folder. The goal here is to keep really good, accurate records, because for your own self, you may be sloppy and you may not be a great record keeper. But when you're the fiduciary, you have to have an enhanced record keeping responsibility to be assured that if anyone were to audit the information, you've got great records at your fingertips. And it speaks about keeping all of these records, the petitions, the letters, inventories, bank accounts, bonds, guardian ad litem reports, and all of it. Keep it all, whether it be digital or in paper form, so you have access to it on an ongoing basis. The next section speaks about other financial and record keeping responsibilities. If you're managing the financial assets of an individual, whether it's in a guardianship and it's the Social Security rep payee account or a conservatorship, you have to appropriately title it. And there's a specific way of doing this. And you can't mix your money and their money. It can't be a joint account. That's called commingling, and that's improper. Each person's monies have to be appropriately titled in a special fiduciary style bank account. And it speaks about making sure you have sufficient cash to take care of living expenses and not locking the money into like a restricted CD or money market where there's no liquidity, because that could put the individual at risk if you don't have money to pay their ongoing needs and expenses. So again, keep all record keeping, the opening and the closing documents, and that all checks that are directed to the individual upon which you're serving as guardian or conservator go into their fiduciary account, not yours, but theirs. So there's a complete segregation of your own personal finances from the person upon which you're serving as fiduciary. Really critical. And All of the banking statements should be communicated to the individual. It's what we call transparent banking, so that the bank statements should be monitored to check for any irregularities or mistakes, or you can't just simply say, well, I didn't look, I didn't notice. No, you have to look. And then, of course, share that information with the person upon which you're the guardian over or conservator. It also provides that there should be, don't use signature stamps. They don't want people stealing stamps or let anyone else sign it, because there's a lot of fraud that can occur within a fiduciary context. Keep copies, keep receipts. We want a corresponding receipt with a bill and a payment, so that everything ties neatly together. It's not an ATM machine where you just pull money out and spend it. It's the opposite. Everything has a corresponding receipt, so that if somebody were to audit it, you could tie in every expense together with an appropriate receipt. If you're unsure, ask the court for permission. There's a process asking the court for a petition for approval of an expense. If you're unsure about whether it's an appropriate expense and you've talked to your lawyer and you can't sort it out and you're unsure how the court will feel about that purchase, ask the court for permission. You could do that through a petition for approval. Again, corresponding bill with a corresponding expense. Computerized records need to be backed up to make sure that they're stored and appropriately protected, so that you can provide that information at the end of an accounting period. And it says keep a record documenting visits to all wards, because there is a requirement to at least visit every 3 months minimally, as well as visits, hospital visits and doctor visits. The annual report requires certain information to be included on that annual report. It's really hard to recreate that at the end of the year, or to remember all the things that you had done. So we urge people, when you're serving as a guardian or conservator, to literally each day keep a journal of everything you've done, who you've talked to, all the information, so that if you ever need to go back, you've got all of that information at your fingertips. Now, again, these are just the basics. There's so much involved in being a guardian and conservator, but some of the basics that the Macomb County Probate Court wants you to know about when you're in that particular role. But to really understand how to navigate through this process, work with a skilled, competent probate lawyer. At the Probate Pro, we're passionate about everything probate. If you have questions about guardianship or any probate or trust-related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.